Welcome to Law Family. This video is helpful to the law students and newly practicing young advocates only. Today, we discuss about the grounds for quashing FIR. The cases mentioned are purely illustrative and provide sufficient guidelines to indicate contingencies where the High Court can quash proceedings and that such power could be exercised where the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is a sufficient ground for proceedings against the accused. First one is where the allegations made in the first information report, that is FIR or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. Second one is where the allegations in the first information report and other materials, if any, accompanying the FIR do not disclose a cognizable offense justifying an investigation by police officers under section 156 of Criminal Procedure Code. Corresponding law section is 175 of BNSS Act 2023. Magistrate within the purview of section 155 of CRPC, section 155 of CRPC, corresponding law section is 174 of BNSS Act 2023, where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offense and make out a case against the accused. Fourth one is where the allegations in the FIR do not constitute a cognizable offense but constitute only a non-cognizable offense, no investigation is permitted by a police officer without an order of a magistrate as contemplated under section 155 of CRPC. Corresponding law section is 174 of BNSS Act 2023. Fifth one is where the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever make a can ever reach a just conclusion that there is a sufficient ground for proceeding against the accused.
Fifth point is where the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceedings against the accused. Sixth point, where there is an express legal bar engrafted in any of the provisions of the Code or BNSS Act or the Consent Act under which a criminal proceedings is instituted to the institution and the continuance of the proceedings and or where there is a specific provision in the BNSS or the Consent Act providing efficacious redress for the grievance of the aggrieved party. Seventh point, where a criminal proceeding is manifestly attended with malified and or where the proceedings is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to inspire him due to private and personal grudge. The power to quash shall not, however, be used to stifle or scuttle a legitimate prosecution. The power should be used sparingly and with evident caution. The complaint is not required to verbatim reproduce the legal ingredients of the offense alleged. If the necessary factual foundation is laid in the complaint merely on the ground that a few ingredients have not been stated in detail, the proceedings should not be quashed. Quashing of the complaint is warranted only where the complaint is so bereft of even the basic facts which are absolutely necessary for making out the offense.
A given set of facts may make out a purely a civil wrong or purely a criminal offense or a civil wrong as also a criminal offense. A commercial transaction or a contractual dispute, apart from furnishing a cause of action for seeking remedy in civil law, may also involve a criminal offense. As the nature and scope of a civil proceeding are different from a criminal proceeding, the mere fact that the complainant relates to a commercial transaction or breach of contract for which a civil remedy is available or has been availed is not by itself a ground to quash the criminal proceedings. The test is whether the allegations in the complaint disclose a criminal offense or not.
Proposals of law which emerge from the said decisions are: first point, the High Court ordinarily would not exercise its inherent jurisdiction to quash a criminal proceedings and in a particular FIR unless the allegations contained therein, even if given face value and taken to be correct in their entirety, disclose no cognizable offense. Second point, for the said purpose, the court, save and except in very exceptional circumstances, would not look to any document relied upon by the defense. Third point, such a power should be exercised very sparingly. If the allegations made in the FIR disclose commission of an offense, the court shall not go beyond the same and pass an order in favor of the accused to hold absence of any menseria or actus reus. Fourth point, if the allegation discloses a civil dispute, the same by itself may not be ground to hold that the criminal proceedings should not be allowed to continue. This video is purely theory. The Honorable Court decides each case on merits. Thank you.